What I have for you today is an interesting case from Denmark about beneficial ownership. And we're looking at one of the parties that litigated called NetApp. As you can see, the background here, NetApp makes the cloud run like a dream. It is a company from the early 1990s which grew spectacularly and provides net services. So our judgment is from 9th of January 2023. It's from the Danish Supreme Court. It's gone through many years of litigation already, and you can see that case number 69/2021 and 79/2021 both concern NetApp APS, two different issues. We'll discuss that in a moment. And then there was a third case also dealing with beneficial ownership from TDC, but we will not look at that here. TDC is a Danish telecom company. So what was going on? In order to understand what was going on, we need to look at a little bit of history of tax in Europe and in the US. Right, so if we look at Europe first, until the late 1990s, it was very difficult for non-European and non-EU, specifically M&Es, to get EU profits out of Europe without any dividend withholding tax. Most treaties had at least a 5% dividend withholding tax. So all these non-EU multinationals thought it was very interesting to have all these subsidiaries in the EU which can pay dividends to each other without any dividend withholding tax under the parent subsidiary directive. But the moment you wanted to take the money home or you wanted to take it out of Europe, there was a 5% or more dividend withholding tax threshold, which stopped you from doing it. Holland was one of the first countries to have 0% to the US under the US Dutch tax treaty, but that only helped US M&Es. And then the situation looked a little bit like this, right? So you had your EU subsidiaries here all over the place, and they could pay dividends to each other. But the moment you got from the EU to the US, for instance, there was a minimum of 5% dividend withholding tax. That got solved when Luxembourg introduced their way out through Luxembourg branches, and Cyprus reduced its dividend withholding tax to 0. And then, more or less by accident, I would call it by accident here, Denmark joined the club and had a 0% withholding tax on dividends out of Denmark. So now you could, for instance, put companies under the Netherlands, Denmark or Cyprus, and then pay out dividends from the EU to these companies. And there would be no withholding tax on dividends under the parent subsidiary directive. And then you could pay it from these companies to an ultimate parent entity, and there'd be no dividend withholding tax on that either. It must be noticed for the sake of completion here that in the Netherlands you would require a treaty to get 0%, whereas with Denmark that was not the case at the time. And for Luxembourg, you needed to have a Luxembourg holding company to get all the dividends from all the subsidiaries, and then you could have a PE of for instance the US company in Luxembourg, and then you could pay dividends from the Luxembourg holding company to the PE. That would be no dividend withholding tax and would be exempt under the Luxembourg participation exemption, and then you could pay a branch profit from the Luxembourg PE to the ultimate parent without any withholding tax either. But Denmark picked up some problems with this because apparently the Commission told Denmark that they didn't like the structure. Why Cyprus and Luxembourg were allowed to continue, or whether they simply don't care, I don't know. But Denmark decided to do something about this. So if we now have a structure where we have a Danish holding company only, and we have all these EU subsidiaries, Danish law said no, it's not a matter of the world anymore that can be above Denmark. It must be a treaty country. If it is a country with which Denmark has a double tax treaty, or another EU country, or a EEA country from European Economic Area, then there would be no dividend withholding taxes. So what we now need to look at is the US rules. And until the 1990s, the US had a credit system. So if you paid a dividend, you only got taxed on the dividend in the US from your subsidiary. but you got a credit for the taxes paid by the subsidiary, except if the subsidiary didn't pay any taxes, there was a problem. So one way to avoid the problem would be not to pay dividends from tax haven subsidiaries. But then the US had very strict CFC rules, which tax the profits of these tax havens as if they were distributed to the US in any case. But then in the 1990s, in the mid 1990s, if I remember correctly, the US introduced the check the box rules, which said, you know what, when it comes to foreign entities, whether we treat them as taxable entities or transparent entities, you simply fill in a form on your tax return and you say how you want us to treat them. If it has been a PE in the past, and you check the box to treat the PE as a company, then remember, we will treat you as if you sold the PE's assets to the company. And if it has been a company and you check the box to make it disappear, we will pretend that it has paid out a dividend to you and now it's become a PE. Okay, but you could deal with the US CFC rules if you set up the structure correctly, and that what companies would then do is they would put Bermuda between, for instance, Denmark and the US parent, the ultimate parent entity here, and then they would check the box on all the subsidiaries. And now it looked as though Bermuda was a company that had PEs in Denmark and all the other EU countries doing whatever the other EU countries and Denmark were doing. So it was not a passive company anymore, which meant that the US CFC rules would not apply. One last point to be aware of here is that the check the box rules were a huge success. So much so that US multinationals could leave billions of dollars offshore, and they didn't bring it back to the US. And the reason why they didn't was because the tax in the US, when they brought it back, would be so high that it simply wasn't worth it for them. The tax could be 30%. I believe that NetApp itself claimed that if it paid any dividends to the US, the tax rate would be as high as 37%. So what the US then did was it said, you know, we need these US multinationals to bring the money home, to use the money at home so it can create jobs for US citizens. So we would give them a grace period under which they could bring their offshore profits home, and we will tax them only at 5 to 6% on that if they reinvest that money in the US. So the so-called 2004 American Job Creation Act was incorporated, and it was very successful. US multinationals from around the world took home billions and billions of dollars and reinvested it in the US, very often leaving the countries where they built those profits with huge debts, because those countries typically needed the money and couldn't just dividend it out to the US. So they had to instead lend money from the US to pay dividends to the US, leaving otherwise profitable companies in Europe with huge debts now due to the US. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. But now we need to come to NetApp and see what NetApp did. It followed what everyone else was doing. It was a US company. It wanted 0% withholding tax out of Europe. It had a lot of European subsidiaries. It could check the box on those subsidiaries. And it then set up a Danish company, NetApp Denmark, which could then collect all the dividends in Denmark, because Denmark had this attractive CFC rule, 0% with dividend withholding tax at the time, but they didn't have the rule about tax treaties yet. So the Danish company was simply placed under Bermuda. And then the box was checked on all the European, including the Danish subsidiary, I assume. And now it looked from a US point of view as if NetApp Bermuda had a lot of branches in Europe who were doing active business. So you also solved the US CFC problem. Then, of course, Denmark changed the dividend withholding tax rules, and now it said you can only get the 0% dividend withholding tax out of Denmark if the parent of the Danish company is in a treaty country. So what NetApp did was it inserted a Cypriot company between Bermuda and Denmark. Cyprus was part of the EU, so there would also be a 0% dividend withholding tax from NetApp Denmark to NetApp Cyprus, and then from NetApp Cyprus, who didn't have a treaty requirement like Denmark had now, you could pay the dividend to NetApp Bermuda, and from there to NetApp in the US. The only problem with this is that Denmark was not happy with the structure, and it said, well, we're not sure that NetApp Cyprus is the beneficial owner of the dividends because it paid on the dividends to Bermuda, and Bermuda is not a treaty country, and therefore we can tax the dividend with 28% dividend withholding tax. But now the question, of course, is why would you stop at Bermuda? Why wouldn't you stop at US? I mean, if you're going to go look through Cyprus, why not look through all the way? And Denmark had to address this issue. And they said, well, let's see how long it took before the dividends were actually paid from Cyprus to Bermuda and then from Bermuda to the US. If that was immediate, then maybe we should give relief as if the US was a beneficial owner. But if it wasn't, then we could treat Bermuda as a beneficial owner, and then Cyprus was not the beneficial owner, and then there would be 28% dividend withholding tax due from NetApp Denmark dividends to NetApp Cyprus dividends. So this was the background to the case. Now it is important to point out that the case itself caused quite a sensation in Europe at the time when the Danish tax authorities started this case. And there was a number of reasons. The first one was this was not one beneficial ownership case. The Danish authorities started several of them at the same time, high profile, big groups, etc. The second one was that the Danish rules, the Danish law, did not have a definition of what beneficial ownership is, so one could not have known it from there. And Denmark at the time did not have general anti-abuse rules for treaties at the time either, right? So many Danish advisors strongly believed that the government implemented a policy change with retroactive effect, because first they tolerated these structures for a number of years, and then all of a sudden they turned around and attacked all those structures for dividends paid from the past. There was also the issue of it was seen that Denmark had a pretty unique interpretation of the concept of beneficial ownership. And remember, this was the 2000s. So if you looked at the OECD text, of course, if you look at Article 11, if you look at Article 12, if you look at Article 10, it talks about the beneficial owner or the ultimate beneficiary in the treaties. You know, so the qualification was always there, but that text was in there for many decades already, and it was deemed to by the practice by the industry, it was deemed to refer to situations where you've got UK trust companies, right, where you've got a trustee and beneficiaries and a grantor, and where in some of these trusts the trustee was a mere nominee, a mere agent, right? That was also the text that the commentaries used, nominees or agents, and it was widely held not to cover intermediate holding companies, because there was also a OECD report on conduit companies, but the wording of the report ultimately was so that Dutch withholding companies, Dutch holding companies, for instance, continue to flourish, because everyone in the world ultimately was comfortable with saying, you know, that the conduit report did not stop these structures from happening. They may have required a little more substance, but ultimately even that requirement was in practice very often very thin. The other issue was that, you know, if you've got Denmark and you've got Cyprus and Bermuda, and then Denmark looks through Cyprus and says you're not the beneficial owner, Bermuda is. The question was, why do you stop at Bermuda, and why do you not then look through Bermuda just like you look through Cyprus to get to, for instance, the US, and then say, okay, well, the ultimate beneficiary, if we are going to look through, we look through all the way, is the US, and therefore we have a treaty in place between Denmark and the US, and we cannot levy withholding tax. And then probably the biggest issue was, well, I said Denmark became a holding company regime by accident, right? I mean, the Danish authorities have been known to be pretty aggressive with regard to corporate multinationals. So there was no expectations there. But when Denmark came with these rules, and it was a way to get dividends out of Europe without any tax, a lot of groups that otherwise would never have considered Denmark put holding companies in Denmark. They brought subsidiaries with undistributed profits to the Danish holding company, and those would have been dividends that would be paid out to the rest of the world without Denmark ever levying a tax. If these companies were not set up and brought to Denmark specifically to make use of the new Danish rules. Alternatively, of course, when Denmark then under criticism of the Commission decided to change the rules, one could have said, well, at least add a grandfathering clause of 2 years to the new rules, saying you've got 2 years to get out without paying any withholding taxes if you came to Denmark because of the way that the old legislation was worded. But that did not happen either. So against this background, the case has quite a history. It went through the lower courts. It went to the EU Court of Justice for an interpretation of beneficial ownership under the Parent Subsidiary Directive and the Interest and Royalty Directives. Now, the Parent Subsidiary Directive actually didn't even talk about treaty directive abuse at the time, but that was a general doctrine that the EU has developed in other cases as well. And the Court of Justice said, you don't need anti-abuse rules in your national legislation to apply the anti-abuse doctrines of beneficial ownership. You can simply use EU law to do so directly. And that's where we're at when we start this case before the Danish Supreme Court.